So over the holidays between Christmas and New Year's, Judge Collier entered an order in the Skanska case that unless you're following this really closely and you have some knowledge of maritime law and how it interacts with state law, it's complicated. So I wanted to give a little bit of a summary of what actually happened and what effect it has on the cases. So let's talk a little bit about maritime law and how it's different than state court law. So whenever there's an accident or some type of legal issue on water, a ship owner has the ability to argue that maritime law applies, and a ship owner wants maritime law to apply because there are very helpful things in maritime law, because it dates back to when, ships were basically the ways that commerce happened, right? And so the laws favored commerce when we were building our country. And the laws were written in such a way that ship owners were helped. So if maritime law applies, it generally helps the ship owner. And the things that are helpful to a ship owner if maritime law applies includes this thing called exoneration from liability, also known as a limitation of liability. So a ship owner can either be completely exonerated from liability from an accident that happens on the water, or they can limit their liability to the value of the vessel, in this case a barge. So the court was first asked whether maritime jurisdiction applies, and the federal court, Judge Collier, did not specifically rule on the components of maritime law applying, but the court did find that that the limitation of liability action would go forward. And so the court then held a hearing or a trial on the limitation of liability issue, and the court basically found that in favor of the claimants, not the ship owners, so he didn't find in favor of Skanska, and he found in favor that there wasn't they didn't carry their burden of proving that they acted without negligence, to summarize it. And so since the court basically dismissed the limitation action, because that's what it is, an exoneration or limitation action. It's actually filed by the ship owner. They're trying to take advantage of the limitation or exoneration provision in maritime law. The court said, no, I'm going to dismiss that. You can't meet that burden. Left undecided, however, is the full application of maritime law, because maritime law can apply potentially, but there are various questions within maritime law that still have to be answered. For instance, and this has not been answered yet by the court, in order for you to have full protection from maritime law, a ship owner, even if they can't prove limitation of liability, if they can prove that maritime law applies in its full splendor, then they still can take advantage of certain prohibitions. Let me give you a for instance, and this is the one that's going to be most relevant to most of the people watching this in this local area. Under maritime law, you cannot make a claim for only economic loss damages, which most everybody around here has from the bridge being out, right? So economic loss means like business losses or increased commuter expenses, those kind of things. That's an economic loss. Now, if you had a barge that ran up on your property and caused physical impact with your property or damage to your property directly, and you have economic loss on top of that, you can make a claim under maritime law because you have direct impact from the barge. And there are claims that are out there in this case where many firms, we don't have any of the direct impact claims, but there are firms that do have the direct impact claims. Those claims, even under maritime law, can argue for economic loss. The large majority of claims, though, in our community are the ones like that we have been handling for commuter expenses, businesses that lost revenue from not being able to service people because the bridge was out, or not being able to have customers from Pensacola, or vice versa. And so those are pure economic losses because those people did not have barges hit their property, right? And so those are pure economic loss claims. Those claims cannot be brought under maritime law. The court, however, in the federal court, Judge Collier didn't necessarily decide, though, whether maritime law applies or not to the economic loss claims. So once the court dismisses the limitation action, you're free to bring your case in state court, and then this argument, which is the next stage. This is what's getting ready to happen. The next stage of this is you can now bring your case either in state court or federal court, and you can argue that maritime law doesn't apply. And if maritime law doesn't apply, then all of the economic loss claims, including the commuter claims, the business loss claims, will have their day in court. If maritime law applies, however, in state court and in federal court, then those commuter claims, those business loss claims, will not have their day in court, and they will not be allowed to be brought. We're at that stage where we have gotten past the limitation of liability action that was in federal court. That was decided against Skanska. And now we're at the stage where we are now, both in state court and federal court, arguing that now, let's now get a court to decide whether maritime law applies. And there's various arguments that it doesn't apply because of the business that Skanska was engaged in was bridge building and versus a typical navigation type accident. So that's where this is headed next. These issues are going to be teed up in either state court or federal court or both places. And a judge or judges are going to have to decide, okay, does maritime law apply to this issue? There may be arguments that's already been decided. There may be arguments that wasn't decided. But either way, this issue is now going to be teed up for either a state court judge or a federal court judge or both. So if you're sitting on a claim and it's purely economic loss or additional commuting expenses or business loss without direct physical impact from a barge. Okay, a barge did not hit your business, did not hit your house, did not hit your seawall, did not hit your dock, did not hit your equipment in the water, then you don't have a direct impact claim. And those matters are still somewhat up in the air. If you have a business that actually was directly impacted by a barge, or a property that was directly impacted by a barge, your standing hasn't changed much in that it's gotten only better because now the limitation, they can't limit your damages now to the value of their barge. It is the value of whatever they can afford. And Skanska is an international company, construction company. So they've got plenty of assets to satisfy these claims and insurance on top of that. So long and short of it is things are still somewhat up in the air. The pure economic loss claims are still viable. They're still going to be something that a judge is going to eventually have to decide as to whether maritime law applies. And if it does apply, obviously, it would likely potentially bar those claims. So stay tuned. We'll keep you up to date. Obviously, we have our clients to keep up to date. We'll also keep the public up to date. If you have questions about any of this, you can find us on the web at zarzaurlaw.com, or you can call us at 855-HIRE-JOE. Thank you.